to, did you want to go over the intro here?
The only thing I had for an intro today is just the reminder that we have, it's on the agenda that we have 4 meetings scheduled. We're back to the once a month schedule. And that is what we have right now. So I only wanted to flag that and say hi to everyone. And if anyone has any questions or needs anything, please let me know how I can help.
Thanks. The first item on our agenda is talking about working draft 4. And so just to sort of give you an outline of what we're trying to do today, we do have a very big agenda. And so we're going to move through this somewhat quickly. And we're trying to give sort of an overview and answer any questions about working draft 4 to begin with. And then we'll be talking about the work that the small groups have been doing on scope and standard of review and dispositional authority and default judgments. And we'd like to get some decisions made on what we can make decisions on. Specifically, I think the scope and standard of review things that were discussed at the last meeting, hopefully we can get some decisions made on that, and we'll see how far we can get on the other items. So I think to start with, Jessica, would you like to talk about working draft 4 a little bit?
Sure. So working draft 4 represents my best efforts to consolidate what has happened over the past almost year, as far as the discussions we had about working draft number 3, the small groups that reported back, and then the changes that we wanted to make, the similar changes from the justice court sections that we did discuss to the municipal court sections that we didn't necessarily discuss section by section. So there's a little caveat there. There were a couple of things that there weren't consensus on that I mentioned at the last meeting. One of them was the scope and standard of review and dispositional authority. There was some consensus on some issues, but not on others. And I had mentioned last time that if I didn't receive further direction, the memo that Jim prepared, that is, I think was sent out with the materials, was going to be what was put in the work draft to at least start the discussion along those lines. And so that is what is in the work draft now. And I understand that there are some elements of that where there are not, there's not consensus, but again, we needed a place to start. We needed some placeholder language. So that is what is in there, sections 19, 20, and 47 and 48. You also received some drafting notes from me. I'm sorry, there's even more to read, but I tried to identify as many outstanding issues as I could before I finalized the draft. But as I was putting everything together and saw how things were interrelating, there was yet more questions, more issues, things that I just wanted to note for the group. And so those are just noted for you in that bulleted or that numbered list of 10 issues. And then I want to just remind people, like, this has not been edited. I've went over it several times, but there could be, small errors, typos, that sort of thing. Want to put that out there. And also there's certain things that I had to conform to our form and style manual, which is adopted by each chamber of the legislature. And there's certain language, there's certain ways that we write things that just have to be a certain way. So I always want to put that out there because people get very wedded to certain language and the way certain things are written. And that's not always possible according to our form and style. And the last thing that I wanted to point out is we are obviously looking for feedback on this. Specifically, if you feel as though this doesn't represent a consensus that you have notes on, or if something is confusing or not clear, it would be very helpful to know what those areas are, how it's confusing, a suggestion for how to fix it. Yeah, and if you just have any other recollection as to what you think the consensus was, because I did my best to record everything that we seem to have consensus on. I looked at the decision and action summaries, but again, we're only human, so there could be mistakes there. And I think that's all that I really wanted to review for that. Thanks.
So we have received comments, written comments, and questions from several people. Thank you very much for those who've got those in. And we would like to continue to receive written comments. If you haven't been able to review thoroughly the draft yet, there is still time and you can send us those comments. And I think right now what we'd like to do is just, we don't want to get into any substantive matters, but if anybody has any questions about things you're not understanding about this draft or questions about how it was done, that's what we'd like to address right now. And then we'll move on to some of the more substantive matters. So are there questions at this point about working draft number 4? Okay, so please do send us in any comments or questions that you do come up with, and we'll figure out how to address those in a meeting or otherwise to make sure that we catch any mistakes that were made in the drafting process or any substantive questions that, as Jessica mentioned, that you think don't represent the consensus of the group. So some of the ones that we clearly know have not yet been decided are the ones that are on our agenda today. And so I think unless there's, I don't see any hands raised, so I am going to go ahead and move into the questions about the small group that's been working on scope and standard of review. And Jimmy went over that memo during the last meeting. And so at this point, I want to just revisit those things that were discussed at the last meeting and see if there are areas where we need to continue to discuss or where we do have consensus. And I guess to start with, I think what is probably the simplest place would, if you all have the scope and standard of review memo in front of you, I'm going to be referring to that since it's got everything kind of consolidated together. And I guess if people want to, I didn't cross-reference the new working draft for section numbers with this. And so I'm just going to go ahead and refer to what's in the scope and standard of review memo, even though this is now somewhere in the working draft. And if people, if Jessica wants to mention which sections we're looking at in the working draft as well, that's great. Or you can put them in the chat perhaps as we're doing it. But starting on, I think on page 3 of the scope and standards of review memo, in general, the idea is that a new term matter has been introduced here to try to reflect what the scope is of particular appeals, because not all appeals will be addressing the entire case. They will be addressing what the particular order is that is being appealed, which may be a pre or post trial order or amended or corrected judgment. And so the definition of matter, does anyone have any concerns with that definition of matter that's on page 3? All right. Sounds like no.
I'll be the first to admit I'm coming off vacation and first reviewing these materials, but why was it necessary to create a definition or a term matter?
The idea is that not everything will be under appeal, like not the entire case will necessarily be under appeal. And so what is under appeal is being termed the matter that's at issue. Am I accurately stating that? So for instance, if it's a restitution order, then that's the matter that's under appeal versus the entire case and everything that's happened in it.
So the term is designed to try to limit the scope of the review to only the one issue that was been brought before the court. Otherwise, the moving party, if they had the ability to do so, would just put in several things that they needed the court to review. Is that correct, Jimmy? I see you nodding.
Yes, that's precisely the reason it's there. So, for example, when a defendant appeals from probation revocation decision, they don't get a whole new trial of everything and restart the case over. It's limited just to that one thing.
That would seem appropriate for judicial economy and resource.
I think it might be helpful to note that under current law tends to speak of that the circuit court has de novo review of the case, suggesting the entire case. On a defendant's appeal of a judgment of conviction and sentence, that's true. The circuit court will have de novo review authority of any issue either the defendant or the state wants to raise, just like they could have in the justice or municipal court. The problem we ran into is that parties can appeal from something other than the judgment of conviction and sentence, pre and post trial orders. For those kinds of appeals, the scope of review has to be limited to the matter from which the appeal is taken, not the entire case.
Okay, any other questions or concerns about the definition of matter? And then the subsequent to the definition is the application, I guess, of the term matter on pages 3 and 4. Are there any concerns or questions about that? Okay, sounds like we've got consensus on that portion. Moving on to page 4, what's termed section 13, because we're referring here to Bill Draft 3, is that an appeal may not be dismissed because the Justice Court has failed to submit the Justice Court case record to the court. I'm assuming there's no objection to that language. Yes.
Just a question, if we could back up to and sub 4, and it says, notwithstanding sections 2 and 3, it's not a jurisdictional defect if the appellant files the notice of appeal in the circuit court, as long as they file a notice of appeal in the justice court. So is that, my question is whether that's consistent with current law, because all that seems to do is say if you, as long as you file timely within the proper court, which is the justice court, it doesn't matter that you filed in the circuit court. So it doesn't provide relief for untimely filing if you went to the circuit court first and then after you file there, you find out after the deadline passes that it's too late. You can't correct that by going to the justice court. And my question is just whether that's consistent with current law.
If I may speak to that, this would change current law. There is a Court of Appeals case, and I don't remember the name of it off the top of my head, in which a woman filed what the court deemed to be a copy of the notice of appeal with the justice court. And that's, excuse me, this is an appeal from the circuit court to the Court of Appeals, and the defendant filed the original notice of appeal with the circuit court rather than with the Court of Appeals. The Court of Appeals, even though the woman corrected it after the 30-day appeal period, the court held that it was a jurisdictional defect to have failed to serve the original notice of appeal on the circuit court, and so dismissed the appeal. that struck me as odd, because in most cases, the notice, except perhaps the color of the ink, the original notice of appeal looks exactly the same as any copy of it. And it seemed to me that the current law elevates form over substance in terms of whether it's an original or a copy. It seems to me that the important features of filing notice of appeal is that the adverse party and the court to which the appeal is being taken receives a copy of the notice of, receives a version of the notice of appeal, and it doesn't matter whether it's the original or a copy.
Heather?
I think that change makes a lot of sense. And I also wondered whether, considering, like in my experience, there's often some confusion differentiating between the different courts for individuals who are representing themselves. And I just wondered whether if a party in good faith serves the notice of appeal on the circuit court, they're confused which court to serve it on. And they do it within the period for filing a notice of appeal. Whether it should be jurisdictional, why it is that the circuit court can't extend the period to go then, correct the error and serve on the justice or municipal court, because that's what we're allowing for timely service. I think in section or paragraph 5. And so it seemed to me that might be helpful for parties as long as they served on the circuit court within the 30-day period, that if they made a mistake, that the circuit court would have the discretion to extend the period so that they could go file on the original court, just like they do for the service issue.
So is that a different proposal then from what's in this section 4, subsection 4?
Yes, well, it's similar in that it's what is already allowed for timely service on a county attorney or a district attorney, and it would be extending that discretion also to the timely service on the original court. So it is a new proposal in that it would be also giving discretion to the circuit court in that circumstance as well.
Any other thoughts or objections to either of those?
I apologize for, what page is this section on? I'm struggling to find it.
Page 4 of the scope memo at the top, subsection.
Sorry, I was late and I had the draft out, not the scope. I'm sorry. Thank you.
Okay, so is there agreement with both of those proposals, or what are folks' thoughts?
So just to be clear, I heard one proposal. And that was to have maybe some good cause language inserted there instead of the narrow language that's there now. Is that what I'm hearing?
What I'm suggesting is, and I'm sorry, I'm having like confusion because I'm looking at both the memo and also the working draft 4. I think that this might be in sections 4 and 41 of the working draft 4, where the final paragraph says that in a case charging an offense, timely service on the county attorney or the district attorney is not jurisdictional, and the circuit court may extend the time for that service. And so my suggestion is that that same language be added to the preceding paragraph, which says, that, that is not a jurisdictional defect if the appellant files a notice of appeal with the circuit court, so long as the appellant timely served a copy of the notice of appeal on the justice court, instead of saying the timely service on the justice court, including that language that would just allow the circuit court to extend that period. So contemplating that if an individual filed in good faith and within the time period allowed in the circuit court, but they messed up with the justice court, that the circuit court could extend. So the same language as in the following paragraph.
And Heather, are you saying that you want that, so long, you would still require that a service have been made, just that it doesn't have to be the original?
No, they would still need to serve on the original court, but that the circuit court could extend the time for that service if they had failed to do so, but did file on the circuit court in the timely manner.
Can we hear from the subgroup?
I'm sorry, I missed that.
Can we hear from the subgroup that worked on this section, what their thoughts are on that proposal?
I don't think this was the product of the subgroup. It was a suggestion when we discussed either the first or the second draft. Discussed by the work group as a whole.
Sorry, I
Yes.
thought Jimmy Brewer and you, Jim, were on a subgroup that kind of worked on this.
Well, the subsections 4 and 5 are set forth here in this memo because it's part of the wording from draft number 3. We weren't proposing to change it. It's only set forth so that you can see the changes to subsection 1.
So I think we went off on a different direction than what the subgroup had been going on here. Essentially, this was in our working draft, and what Heather is proposing is an additional change to allow if a copy wasn't originally served on the justice court, then there could still be, or I guess it would be in the circuit court, if the copy would have to be served on both courts essentially, so we the time could be extended if it wasn't served on both courts. So this is something that's different from what the subgroup was working on. So maybe folks can comment on that later if you have any further thoughts, since this wasn't part of the memo initially, the discussion. And we can table that at this point and move on. Does that sound good? Okay, so the next section in the scope memo is about the standard of review. Let's see here. So the section, what's labeled section 13 sub 3. After the appeal is perfected, the matter shall be deemed pending as if the case had been originally commenced in the circuit court, and deciding the matter anew. So this is the de novo review standard. Are there any questions about the wording in there?
And I would say, just for clarity's sake, this is another section where the main change to 13 sub 3 at least is really just replacing the word case with the word matter. So it's that more limited scope that we talked about earlier.
Thank you for clarifying that. Okay, so are there any objections to that language, or does that seem fine to everyone? Okay, hearing nothing, I think we'll move on. to the next section, which is still on page 4 of the memo, labeled section 16. Jimmy, maybe you can explain better than me what the intent of that section is.
Sure. So relative to working draft 3, this cuts down on certain types of appeals that a defendant can make. Working draft 3 basically cut and pasted some language from chapter 138. This says, well, maybe some of those don't work for justice court to circuit court appeals, so let's just take them out. This is compared to current law, this gives defendants some more things, but also takes, when you read it in context of the whole, takes some things away. Appeals, I mean, it lists the categories of appeals that are available, so I'm not going to just talk through them, but when you read it in context of what comes after, it's the one restriction is that appeals from no contest pleas now only lead to a new sentencing. You don't get a new trial, you don't get to reconsider the plea. The plea now stays and you just have a new sentencing. Whereas under current law, as far as I can tell, the result would be if you appeal from a judgment of conviction after a no contest plea, you get a whole new trial.
Comments on that draft? Justice Duncan?
The first one is just a phrasing issue. In section A, it says, defendant may appeal from a judgment convicting defendant, blah, 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 regardless of whether the justice court imposed. And then it says fine or imprisonment as a sentence for the conviction. There might be other, maybe we should just rephrase that, because there can be other sentences besides a fine or imprisonment. I think you can get a sentence of discharge. And so there's just a phrasing issue. We might want to phrase it so it doesn't look like it would only be those two types of sentences. So that could just be more general language. That's my.
Such as regardless of the sentence imposed for the conviction?
Yeah, like regardless of the type of sentence imposed, that just might cover all of the possible bases if we're not suggesting a limitation.
Judge Cross?
I think that makes a lot of sense what Justice Duncan is saying in terms of that language change. My question was on subsection 2, because we had a meeting with a subgroup where we reached a consensus that the defendant who's appealing an order denying a motion for relief from default, that there should be a standard of review of abuse of discretion. And I don't see that language in the draft, and I didn't know if we were going to deal with that today or that's to be tabled until we come up with the final draft of that from the subgroup. But I wanted to. The
default judgment issue is on our agenda later. Yes.
Okay. Then I shall be clear about that.
I would just very quickly point out that it's in the work draft, but because the memo is just focused on the scope of review, it is not in the memo.
Right. This was the earlier memo and not from the default judgment group. Any other comments on page 4 to 5 of the memo, that what's under section 16 there? Justice Duncan, do you have your hand up again, or go for it?
I just had a question about D. It says an amended or corrected judgment that's entered after the judgment of conviction and before the expiration of the appeal period for the original judgment. So it sounds like the draft is saying if you enter trial court, local court enters a judgment, then enters an amended judgment, you can appeal that amended judgment. Is that right? And so my question is, what happens if you have an amended judgment? The first judgment is entered, 30 days run, appeal time is done. Local court amends the judgment and says, oh, I want to change the sentence. Is that later amended judgment appealable?
No. So the scenario that this is saying is appealable is local court enters a judgment, then like 2 days later realizes, oh, there's a typo in that. It should say 150, not 1,500. that sort of change, basically, now you could just appeal from whatever judgment and it's all going to work out and it avoids sort of an error. The scenario here is you're talking about is local court enters a judgment, defendant doesn't appeal from that within the 30 days. Sometime after that, the local court enters an amended judgment for whatever reason. The defendant would not be able to appeal from that. However, in the probably unusual circumstances where there's going to be a problem with that, there could be mandamus, there could be writ of review, there are going to be other things that they could do. But just appeal is figuring out what would happen in those appeals is very tricky. And it seems that most of the time, the answer is going to be nothing productive.
So that was something that I had flagged as well. And it seems like it's different from what is normally done with appeals. For example, in ORS 18.107, which says unless a correction to a judgment affects a substantial right of a party, the time for appeal of the judgment commences upon entry of the original judgment. And I think usually that's the rule is if an amendment substantially changes what was done, what was in the original judgment, then that is appealable because of that substantial change. Is there a reason not to follow that here?
So the thinking is basically to parallel a policy that I believe is in 138.105 sub 10, which has to do with, which does sort of a similar thing in criminal appeals where if the amended judgment is entered shortly after the original judgment, it just fixes an error. You can appeal from the amended judgment. It basically supersedes the original judgment. You can appeal from the amended judgment and you do review of everything. Basically, this avoids a trap for the unwary where, like, the circuit court is like, well, you appealed from the wrong judgment. That's not permissible. This basically says if it's within the same short period of time, then both judgments could basically be treated as interchangeable for purposes of appeal. So that's basically the point of this. It's really just to avoid a trap for the unwary without really creating a substantive change.
Judge Cross.
Yeah, I think, Krista, that I was thinking the exact same thing that you were thinking about in terms of that issue and whether it's a substantive change. And if it's a substantive change, seems to me that you now have another appealable order and to file the notice of appeal within 30 days. Because otherwise you've made a substantive change to a judgment and precluded a defendant from having the right to appeal that. I don't think that that's the way we should go. And I don't think that a mandamus or a writ of review is necessarily the satisfactory alternative to that. I would rather reflect the language from Chapter 18 as the standard of whether somebody can appeal an amended judgment.
Lindsay?
Also, one last thing: if there's if there's an amended judgment that is made as contemplated in here within the 30 days, does that not also then that amended judgment becomes the new 30-day mark, even though it may not be a material change? I would say I don't know if that's clear from the language we have here, but I think that's the way it should be.
Lindsay?
I was just gonna clarify what happens if someone has already appealed from the original judgment, but I thinking through this as we were talking, I think that appeal just goes forward, and since it's a new trial de novo, then it doesn't, then the circuit court just doesn't have to consider what happened or what the local court did in the amended or corrected judgment. Is that right?
Correct. In fact, I'd go further and say that once the notice of appeal has been filed, the local court shouldn't be entering an amended judgment. Now the case is in the circuit court. So I'm not sure the local court would even have authority to enter an amended judgment.
Tony?
Trying to unmute myself. Thank you. I agree with Judge Cross on what he has said. And it occurs to me sometimes we'd have a municipal court pretty big restitution numbers that came in a long time after 30 days. I think the statutes might allow victims to put in different information in with city prosecutors. And that can be thousands of dollars. And that would be a significant change that somebody would want to appeal from, and they should be able to. because it's one of the biggest parts of the case. I mean, it used to be restitutions to be a few bucks, but sometimes we're getting to, you know, you hit a telephone pole, it might have cost you $25,000 in a hit and run case. So I think that I agree with Judge Cross on that. If it's a substantive change, there should be the clock starts over.
If I could just clarify, a restitution supplemental judgment, that is appealable, no matter when it's entered.
I think that there may be, I mean, I can just say from my experience as an appellate attorney, there are a number of times when we get amended judgments that, you know, create a surprise to what had happened previously, and it's something different. And then, so they may not have appealed the original judgment, but they want to appeal the amended judgment because it is something different. And so that's my my interest here. And it doesn't sound, it sounds to me like that's what Judge Cross is saying and others. Is there anyone that disagrees that people should be able to appeal if there is a substantial change from an amended judgment that would happen outside of the 30 days to appeal from the original judgment? Jimmy, you're still thinking that it should just be a mandamus or writ situation?
The problem, as I see it, is not in this question, which seems reasonable on its own, but in the subsequent question, which is what happens in that appeal, right? For example, should the defendant get a whole new sentencing? That doesn't really seem appropriate if this is well past the entry of the original judgment. Ordinarily, an amended judgment, one of the few circumstances where it's going to be appropriate is when there is some error in the original judgment and the Justice Court is saying, no, actually what I meant to order was this other thing. And it seems then that the circuit court proceedings potentially either become the circuit court making its own determination of what the Justice Court originally said, which is a very strange proceeding to have, or the circuit court making its own decision about a particular aspect of a sentence in isolation, which is also unusual. It's not as simple as just saying, well, we can look at the transcript and see this is what the Justice Court initially said. This new thing it's doing is wrong. It won't be that clean. So that's sort of the issue I have is these are going to be very confusing appeals for a circuit court to handle.
Jordan?
Thanks. And I guess I should preface this with saying that this is my personal statements and not anything to do with OPDC's agency policy or anything like that. But I will say that when we start talking about relying on mandamus and writs like that to deal with these sorts of situations, those are fairly complicated. And if we're talking about times when people are pro se, that's going to be a small nightmare to ask a pro se person to put together a writ of mandamus. Having tried as an attorney to put together a writ of mandamus, I wouldn't wish it on anybody else. But the other consideration is that I don't know that we would be able to get attorneys for people to do that. I don't think any of the city courts, at least none of the city courts that I've worked in, would have considered that as part of a defense contract, and there's no money at the state level to do it, and I don't think any authority at the state level to do it. So that concerns me. My other point on that is that if what we're trying to do here is simplify the process of appeal, it seems like lumping as many different problems or issues that someone might want to challenge into the appellate stuff is going to be our better route than trying to create multiple ways to challenge something.
And can I just make one other comment about where this might come up? If for instance, there was some sort of error in the judgment or misunderstanding about what was going to go in the judgment, and then that was corrected more than 30 days after the initial judgment, Again, if the initial judgment didn't have anything problematic in it for the defendant, but then the later one did because of the correction, then it sounds like it wouldn't be appealable here. Judge Cross.
Perhaps there could be language in there to say that if the appeal comes from an amended judgment entered after the 30-day period, that the appeal would be limited to whatever that substantial change was. Whatever the fact of that basis would have, the appeal be limited to that issue, whatever it may be.
Judge Kidd?
Dan had my idea. I just think I'm worried that we get way down the line and then we have a de novo appeal that comes way back to the guilt or innocence phase. And so to the extent we can cabinet, I think that would avoid blowing a hole in the justice courts.
Justice Duncan?
I think there's case law that supports that approach. We have having amended or corrected judgments that have a new term that creates an issue that didn't exist before, and the defendant didn't appeal the original judgment. The defendant, when you're going from the circuit court to the Court of Appeals, will file an appeal from the amended or corrected judgment. That appeal will be too late as to everything that didn't exist in the original one. And so the timeliness kind of affects what's appealable. What will be appealable is that new aspect of the corrected or amended judgment. And I think that is how it's been handled at the Court of Appeals. So it's kind of limiting, because if you didn't appeal everything that was the original, you're limited to just what the issue is in the amended or corrected, which is what I hear people saying. We want to make sure that there is an opportunity to have review or circuit court consider that new issue. So I think that will happen. And if we need to reference that case law, we can probably do that.
Okay, I would like to move on here. So any more comments on this, or should we go ahead and try and draft language to that effect about cabineting it essentially to the issue that is new?
I guess I'm wondering why that's necessary. I mean, the reason that we introduced the term matter is so that the review by the circuit court will be limited to whatever the subject of the notice of appeal is. If the appeal is from an amended or corrected judgment entered after the 30-day appeal period from the original judgment has run, then necessarily the appeal is limited to whatever it is was changed. I see from Jimmy's point of view, what's awkward is that if the justice or municipal court kind of out of the blue issues an amended or corrected judgment that substantively changes something, unless there's a letter, opinion, or something that will give us a clue as to why the local court did that, the parties may be forced in a situation where they have to call the local judge as a witness and said, Your Honor, 60 days after you entered the original judgment, you issued this corrected judgment. Why did you do that? So that may be awkward, but I think in order to protect the defendant's rights, or perhaps even the state's rights, I mean, there may be situations where the judge changes something that the state is not happy with, or the city, whatever. I think in order to protect those rights, maybe the group is correct that we do need to allow an appeal from it, recognizing that the de novo hearing limited to that issue could get awkward.
Okay, a couple more comments, Paul?
Yeah, I'm not sure that just the definition of matter takes care of the problem here. I mean, because when we have an amended judgment, you're going to appeal from that amended judgment and every term that is in it. And so I think if we're going to allow an appeal from an amended judgment that happens after the 30 days, I think we need to be express and say you can only challenge something that was changed between the original judgment and the amended judgment. I don't think what we have in the definition of matter will take care of that problem. Otherwise, I agree with everyone that it seems like if there is a change that a party would want judicial review of, they ought to have that opportunity.
Judge Cross.
I agree with what Paul just said, but I also, in my experience, when the circuit court judges get these appeals, are used to just doing them de novo. I think that having the express language in there would also provide the advantage of letting the giving the notice to the circuit court judge that this is a limited subject matter for the appeal.
Jessica?
I don't know how wedded we are to the idea of this being limited only to substantial change, but I would just caution everyone that that's going to be very difficult to define. I think it needs to be any change, because if we now have a definition of substantial and we're putting that in the section about what it is and isn't appealable, we take a section that is very, very clear. These judgments and orders are appealable. Anything not listed is not, and we add a whole lot of gray area. So I think it needs to be, they either are appealable or they're not. And then in the proceedings in circuit court, we can create those limitations.
I think that my recollection is that the case law is to something around matters that arise from an amendment. So perhaps that's, rather than saying a substantial change, something that an appealable issue that arises from, and maybe that's not about appealability, then maybe that's about a reviewability. Perhaps we need to mess around with that a little bit more and come back with another proposal. If anybody has specific language ideas, why don't you email them to us? Okay, let's move on. Unfortunately, we only have 10 more minutes. We have a whole lot more material here. And so the question is, I guess, how to most efficiently do this. We can move on to some of the other, there's just a little bit more about scope of review in the memo. And then we have issues of what happens, the disposition after review. And so how about we try to finish off here, if we can, in the next couple of minutes, the rest of the scope part and see if we get there. So I'm on page 5 at the bottom, starting at page 5 and then going into page 6, the section 17 changes. Jimmy, can you summarize what those are?
Yes. So the only thing we do is we delete subparagraph or paragraph H, because paragraph H only relates to a type of order that can occur in Measure 11 cases, and there are no Measure 11 cases in justice courts.
Okay, any objection to that? Okay, moving on to section 17A portion. Jimmy, can you explain that?
Yeah, notwithstanding that we tried to limit the scope of review from appeals of something other than the judgment of conviction and sentence, but in Jimmy's original memorandum, he pointed out that there's some areas where we might need to have a more specific standard of review. And so what section 17A, B, and C attempt to do is to define the standard of review in very specific cases. So that's what those do.
Okay, if are there any comments or concerns about the wording in those sections? Are there any objections to going forth with that and what's already been, essentially, these have already been drafted into work draft number 4. Justice Duncan?
I just have some phrasing suggestions for clarity purposes, but I can send those along in writing without delaying the conversation.
That sounds good. Any other concerns about those sections or objections? Okay, great. And we will be going forward with some sort of technical changes, wording changes for clarity that we'll pass along to you as comments come in about them. We'll address those later. Justice Duncan, did you have something else there?
Sorry, yes. We had skipped over in subsection 16 about probation conditions. It's addressed in footnote 4 and just says we're not recommending a defendant be able to appeal orders extending or modifying probation. And I'll just send written comments on that. I think you can in criminal cases if you're in the circuit court, and I just didn't know whether the group wanted to not allow that when you have probation in the justice court. That would be a difference between your local court and your circuit court, but I'll just send written comments on that one. I just wanted to flag that issue.
I can say very briefly, the purpose of eliminating those is there are potentially awkward situations where probation is still ongoing in the justice court and the circuit court is rehearing de novo certain things. The justice court may have its own subsequent violation hearings, and those could create some very awkward situations. Whereas if it's allowed only when the probation is revoked, that basically prevents there from being any overlap. It's either in the justice court or the circuit court. And obviously revocation is by far the most significant of those things.
Okay, so that, other than the conditional pleas section at the very beginning, I think that we have covered the scope portion of this, or scope and standard of review portion of the memo. Now, the conditional pleas portion, can you explain briefly, Jimmy, why the group didn't think that conditional pleas would work in de novo review?
Sure. So I think we went about figuring out, okay, what should actually happen in appeal from a conviction based on a conditional plea? And by the time we'd worked out what that would look like, it ended up being more like a transfer provision. And thus, it sort of became an awkward thing where we were using this conditional plea framework to effectuate what was functionally a transfer decision. And the simpler way of doing it became just, let's make it a transfer rather than this somewhat awkward conditional plea way of doing it. That's maybe not super clear. The simpler explanation is conditional plea is something you enter in the circuit court, you appeal to the Court of Appeals, you reserve some specific pretrial issue, Court of Appeals potentially decides that, remands, and you can withdraw the plea. That is awkward. I think they're awkward in a number of ways when you're going from the justice court to circuit court. And the purpose of the conditional plea is to allow somebody to get appellate review from of a, say, motion to suppress, even when in a case where they don't want to have a trial. It's just sort of an efficiency time-saving thing. We don't need to have a trial. We can just do this plea, but you're not losing your right to appeal that. I think in the justice court to circuit court, the even more efficient way of doing it is if you have this motion to suppress issue or other type of pretrial issue that you want to get up to the circuit court, you want to get up to the Court of Appeals, and everybody agrees that it's more efficient to do that and not have a trial, just transfer it.
Are there, Heather?
I had a related question. So that part made sense to me. And I think a part of this conversation too was whether to allow appeals of no contest pleas, and I think the group had decided not to, and that made sense to me too. But I wondered whether there was an error in the working draft in section 37, paragraph 2 for municipal courts, because it says that a defendant cannot even enter a no contest plea. Not only that, it couldn't be appealed, and that language isn't in the justice court section, I don't think, in section 5. And so I was wondering whether that was intentional or if I'm reading it wrong, and if anyone had any further information on that.
I can answer that. That's not meant to say that no contest pleas are not allowed at all. And if it implies that, then that needs to be fixed. I added that in. There is a similar section in the justice courts that I'm not immediately able to find where it does create that limitation on no conditional pleas. And I think just in moving that from the justice courts to the municipal courts, the ambiguity was added. So that is not an intentional drafting.
Okay, we only have 2 minutes here. I think we're not going to be able to get a decision on the conditional pleas section of this. So people can maybe send in any comments you have or concerns about the language around conditional pleas or lack thereof, and the idea of doing a transfer instead upon everyone's agreement.
Krista, may I make one comment about that? It should be borne in mind that transfer is a different animal when it comes to municipalities to the circuit court. Often what happens is the prosecutor from the from the municipal court, when the case is transferred, comes off that case and the district attorney picks up the case. So that should be taken into account for when the decisions are now being made about the prosecution. Another agency would be taking up that mantle in most cases. So that should be a thought process. In my mind, a conditional plea means we're in this court, this court's made an error, we're going to go ahead and enter a plea in this court, have this prosecution office handle not only the appeal, but also when it comes back, handles whatever the issue is in the case and make those decisions. So I don't think it's as simple as it looks like a transfer, at least not in Clackamas County. It would make more sense to leave a language allowing for a conditional plea to resolve that issue amongst the parties in the lower court.
Okay. So we still have some very significant issues to address in order to get this bill ready for the legislature that we don't have agreement on, as far as dispositional authority and including what happens with default judgments. And so I guess I will need to talk with folks about whether we need to have an additional meeting because we do need to keep progressing forward here on this. Any thoughts at the moment about forward movement here?
I appreciated the OJD memo that you sent out. I think maybe today or yesterday regarding enforcement of judgments, and I'm in agreement that OJD should enforce their own judgments. And I don't know if there was disagreement among the other judges on that, but I just wanted to tell you my opinion. I didn't know if that was a controversial topic where we didn't have agreement, but I was very persuaded by OJD's memo.
I think we don't have time to get into that right now, but I can just say that yes, there's not agreement about that yet. And so I do think we may need to schedule another meeting to talk about what we'd hope to get to this meeting. So I guess I will talk with the other with Amy and Justice Duncan and figure out what we can when we can schedule that. Any other thoughts on the process here? I really appreciate everyone's time. There's a lot here and a lot to get through. So the more that people can send us in their thoughts and comments, the more we can organize these meetings efficiently, and so that we don't have to sort of start from square one every time. So again, much appreciated for the memos that are coming in, as well as just email comments about specific sections or questions. Keep those coming. Anything else for the good of the order? Okay, thank you. Have a good afternoon.